Scared in New Boston, and Scared writes in and tells us that my son borrowed $75,000 from me to purchase a home. He said he was going to give me a lien on the property, but his wife is on title to the home with him. And now after the closing, she refuses to let him sign anything that acknowledges my money that I gave them for their new home. She says it was a gift and that they reported the money as a gift to their mortgage company. I am so angry and so concerned about my money. What can I do here? From Scared in New Boston.
Yeah, it's really unfortunate. I do want to, I'm going to keep going back to that earlier question about like the attorney and free consultations. Here's an example that like if somebody called me with that question, I would of course be very empathetic, but at the same time, I'd have to say, hey, can you do me a favor? We're going to need to see the documents that were signed, and we're going to need to see the information, showing me that you conveyed the 75,000. How was it conveyed? Was it a deed? Was it wired? Did you put a memo in the memo? Did you write the word gift? Did you give a gift letter to the mortgage company? I mean, there's all these questions I have, but in general, let's just hypothetically say that, pretend that she never meant it to be a gift, okay? And they had an agreement between the family members. Hey, I'm going to give you the 75 as a down payment. If there's no gift letter, if there's nothing that references gift, but there's conversation, there's something called promissory estoppel or promissory estoppel, where the family moved forward and took the 75,000, and so it's evidencing some type of arrangement between the parties. So I believe, if she says I gave the 75, it wasn't supposed to be a gift, it was a loan. Okay, if I can show the wire and I can show the 75 and I don't see anything about a gift letter, I'm going to assume that that is most likely true. Then the other thing is to this question, which is that the wife doesn't want this lady's son to sign anything. Well, that's a problem, okay? Because there's two people on that deed and she has certain rights. The daughter-in-law, it sounds like, has certain rights. She doesn't have to be compelled initially to sign over like a deed or some type of acknowledgement of this lady's interest. Here's the thing. I'd like to know the attorney who reviewed their documents before they closed on this property. I have a feeling there was no attorney, okay? The other thing is, it does happen a lot in family situations where people want to be good to their family members. They want to help their children. I wrote a book called Shady. It's about doing business with family and friends and how to protect yourself. And this is a perfect example of what you need to do when you're about to allocate huge sums of money to help your family members, whether it be for a business, a home, or what have you. You need to have the consult and the advice of an attorney. Okay. So in the end, I'm kind of getting off topic a little bit, but she does have rights. We just have to see how she signed the paperwork. I also want to suggest that this daughter-in-law said something about that the money was a gift, and they made a statement to the bank that there was a gift. It's problematic because if there's a gift letter, usually these gift letters that banks use have some language in there that says, hey, this is a gift letter. We're relying on you not to have to come back against the borrowers because we're making a loan to these borrowers, and we're going to assume that they don't have to pay any more money back than what they currently owe us, being the bank.
Right.
See? And so the bank is kind of relying on that letter as well. I'd like to see what the closing package has. Okay.
No, that's a good point, because you're only so financeable, and perhaps the reason why they needed that 75,000, I'm just speculating, is because they weren't financeable above and beyond. So that would be a problem that I didn't think about, for sure.
You really have to, Blair, just like the mechanics of doing intake and dealing with people with these type of issues is we would want to see a complete loan package, a closing package, I'd want to see the transaction, how it, the closing settlement statement. I'd also want to see any emails, text or anything like that, because you'd be shocked. I mean, we've gone in many cases where we're going down one route and then all of a sudden we get a text we find, and that has some language in there that changes the whole case. In fact, it's happened twice in the past. Today's only Monday, but last week, well, no, last week it happened twice to us where, you know, it's constantly in litigation. You know, 1 minute you're up, the next minute you're down. And, you know, we have so many instances where just one text will completely change the outcome of a case.
Isn't that something?
So I'll tell this lady not to despair, but it's too soon to speculate what she has unless we saw the paperwork.
Mhm.
But yeah, there are things that we can do to help protect somebody's interest once we see the paperwork.
Mhm.
Okay.
I gotcha.